Hi, my name is Eileen Mostricht, and today I wanted to talk about the challenging topic of planning for blended families. So this is an area that is actually one of the biggest in the biggest amount of litigation in the probate courts is children from prior marriages going at each other because they're upset that one set of the kids got everything and the other set got nothing. So the way that this happens is it's often unintentional, but people get married and often it's the second marriage, and then what they'll do is just sort of instinctually and naturally they'll leave everything to their surviving spouse. But then what happens is that that surviving spouse, when they're doing their own estate planning, because maybe that surviving spouse is going to go on living many more years, then they do their own estate planning or redo their estate planning, and they'll just sort of naturally and instinctively leave everything to their own kids. And that means that the children of the first spouse to die end up with nothing, and they are livid. Now, adult children don't have a right to an inheritance, but they're understandably upset when they see one set of kids getting everything and they're getting nothing. So planning for this can be done, but it takes some careful planning, especially in Florida, because spouses have rights. They have rights to a home, they have rights to a certain percentage of the deceased spouse assets. So we have to factor all that stuff in. And the nuances of this go beyond the scope of this video. But just suffice it to say that you need to really do this planning, and you really need to think about it, meet with an attorney. We got to think about it all the way through from both sides. So if what's going to happen if one spouse dies first? What's going to happen if the other dies first? There are a lot of different things that we could do. For example, the spouses could set it up so that if they die first, whichever one dies first, a certain amount of their assets are going to go automatically to their adult children, and that could help ease the frustration a lot of times if those adult kids don't see everything going over to the surviving spouse and then inevitably or possibly ending up with the other set of kids. They could buy, if they don't have the assets to do that with, they could always buy a life insurance policy that leaves their own adult kids as a beneficiary. Another good option that is used a lot is trust planning. So when we do trust planning, we can say in the trust that after the first death, certain assets are held in a protected trust, that the income can go to the surviving spouse, and the principal if needed, but ideally the surviving spouse will use his or her own assets for the rest of his life or her life, and then will only need the principal from this protected trust if they run out. And then in that case, it would be available, but otherwise it would be held in this protected trust. And then when the surviving spouse dies, what's in this protected trust will go to the children of the first to die. And then what's ever left over in the estate of the surviving spouse will go to their own kids. So there are a lot of different, or I don't want to say a lot, but there are some alternatives in doing this planning. And again, we have to keep in mind the spousal rights in Florida and factor that all in. It's kind of like a puzzle. But if you are on a second marriage and you have children from a prior marriage, please do your planning, save your kids the heartache and the frustration that very often ends up afterwards, and get this planning done as soon as possible.